Hello, this is family law attorney and mediator Bryan Ginter, owner of Ginter Family Law. This video will present an overview of family law mediation as an out-of-court process to resolve almost any family law issue. I have a special passion for non-adversarial resolution, and as a result, I have extensive training and experience with family law mediation. When I use the term non-adversarial, I simply mean that the parties to a dispute have a formal written agreement that they will not bring their case before a judge, nor will they implement some tools found in litigation. While mediation has many applications, the mediation discussed in this video relates specifically to family law issues such as divorce, legal separation, child custody, child support, and so on. Additionally, the mediation principles and procedures mentioned in this video refer to how mediation is practiced at Ginter Family Law. Maybe you are thinking about a divorce, and you want to know if mediation is a comfortable process for you. Maybe you are just starting out, and you don't know what resolution options are available to you. Or maybe you know of a friend or a loved one that is facing some family law issue and you are looking for a procedure that may help. Regardless of the reason why you are watching this video, it is my commitment to mediation as a non-adversarial process that spurred the making of this video. And it is my hope that this video helps clarify family law mediation and to point out some of the very powerful potential benefits that mediation can provide. So then, let's get started. So, what is mediation exactly? Mediation is an out-of-court process to resolve almost any family law issue. The strict definition of mediation is assisted negotiations. When parties agree to mediate their family law case, they have a series of out-of-court meetings with a mediator who facilitates agreements between the parties. Here are a few highlights regarding mediation that you should keep in mind. Number one, the mediator is neutral to process and impartial to outcome. While a mediator may be an attorney, the mediator is not meeting with the parties as their attorney. The mediator does not become either party's attorney of record, and unlike an attorney, the mediator does not have any obligation to advocate for either party's best interest. Number two, it is not the mediator's responsibility to bring the parties to agreements that they would have reached had they brought their case to court. Instead, the mediator brings people to acceptable agreements. Acceptable agreements are agreements that are satisfactory to both parties. Number three, the mediator does not provide any recommendations to the court in the event there are any outstanding issues that could not be resolved in mediation. Nor does the mediator make any rulings, judgments, or orders on any issue that could not be agreed upon by the parties. And number four, ultimately, everything that is done in mediation is done by agreement of the parties. In fact, the very first agreement the parties reach is the agreement to enter into mediation. As such, mediation is completely voluntary and it can be terminated at any time by either party. Family law attorney mediators provide two types of help: substantive and procedural. Substantive help is what I mentioned earlier, to facilitate agreements. For example, if there is a divorce action and there are minor children involved, some of the issues to discuss will include child custody, child support, spousal support, and property division. And the mediator will facilitate agreements with those issues. I sometimes have people tell me that they thought that their case could not be mediated because they didn't have agreements on all of their issues. It is definitely not necessary for parties to have any agreements before choosing to mediate their family law case. In fact, disagreements are expected. Facilitating agreements goes to the heart of why people hire a mediator. The second type of help a family law mediator provides is procedural help. Some examples of procedural help include the following. Number 1, preparation of legal documentation. Number 2, filing legal documentation with the court on behalf of the parties. And number 3, serving legal documentation on the parties. As you can see, even if the parties believe that they can easily reach agreements in their case, the procedural help provided by a family law attorney mediator can be invaluable. In family law mediation, a party may hire a consulting attorney. A consulting attorney does not attend the mediation sessions and is not overly active in the case. Instead, a consulting attorney is available to consult with a party at any time throughout the case. Additionally, at the end of the case, a consulting attorney can be given a draft of the party's agreement to review and to provide feedback before the agreement is signed. Mediation offers some very powerful potential benefits over litigation. Here are a few. Number 1, more flexibility. In litigation, if your case goes to court, a mathematical formula can be applied. Law plus facts equals ruling. The judge must apply the law to your facts and issue a ruling. In an out-of-court process, such as family law mediation, most of the time the parties can deviate from this formula and agree to something different than what they may have received in court. Number 2, confidential discussions. When parties litigate family law issues, most of the cases are in open court for everyone to see and hear. There is a room full of people who have their own cases waiting to be called. There are also attorneys, the judge, the court staff, and so on. When it's your turn, you are center stage, and you need to be proficient with oral argument and have knowledge of the law. Additionally, family law topics are sensitive, and case details that may not even be shared with friends or family will be heard by complete strangers. With mediation, there is only you, the other party, and the mediator. And all discussions, unless otherwise agreed, remain private and confidential. Number 3, craft your own outcome and less likelihood of future litigation. When you go to court, it is the judge who decides your case, not you. Most people go to court to win. However, oftentimes, both parties feel as though they actually lost when leaving court because neither party is happy with the judge's decision. On the other hand, in family law mediation, both parties are satisfied with the results since they are the ones that agreed on the terms. This leads to a win-win scenario. In litigation, if someone is not happy with the judge's order, this can lead to a vicious cycle of more litigation because the unhappy party will want to go back to court to modify the order. On the other hand, if the parties craft their own outcome, it is less likely that they will go back to court anytime soon to modify the order because they are both happy with the results. Number 4, less time and money. I once heard a statistic at a seminar that litigation costs are 3 times the cost of mediation. To put it another way, if you spent $10,000 in mediation, then you would have spent $30,000 in litigation. While I cannot verify the accuracy of this statistic, it has been my experience as both a family law mediator and a family law litigation attorney that mediation cases are typically quicker and less expensive than litigation. Traditionally, frequent trips to a law firm were necessary for such things as signing documents, meeting with an attorney, meeting with a mediator, etc. At Ginter Family Law, coming to our office is not a requirement because we offer web meetings. As long as someone has a device that connects to the internet, such as a desktop computer, a tablet, or a mobile phone, we can meet face-to-face and also review documents in a virtual meeting. At Ginter Family Law, you no longer have to waste time and gas on the road. Additionally, many documents can be exchanged electronically. Using digital transfer and web meetings increases our efficiency and at the same time protects our environment by saving trees and reducing car emissions. Ginter Family Law is proud to have taken a green pledge, implementing ways to help safeguard our environment. We have a great amount of information at our various websites, including ginterfamilylaw.com, mediationfamilylaw.com, and familylawplacer.com. Feel free to visit and browse our websites for more information on mediation and many other family law topics. If you would like to schedule a free initial mediation consultation, call us at 916-419-1161. We are happy to help. From Ginter Family Law, I am family law attorney and mediator Bryan Ginter. Have a great day.
Going crazy, can't you see?